you 30 minutes of free
Good morning,
legal
Facebook
advice.
Livers.
Call in now with your questions. 877-850-8585. That's 877-850-8585. Now here's your host, Attorney Jeff Vastola.
That's me. Good morning, everybody, and thank you so much for tuning in to Vastola on the Law. I am here every Saturday morning, almost every Saturday morning, to give you free legal advice. I was not here last Saturday morning. You heard a replay because I was in Colorado on a brief guy's ski trip. It was fun. Still trying to figure out when to hit the go button on Facebook Live because I sit here like a doofus for 30 seconds or so while the intro is playing, but I'll figure that out eventually. I am Jeff Vastola, your host. I am an attorney. This October, coming up on 25 years as an attorney. It's hard to believe. I don't feel that old. And I am wearing my Jupiter Christian shirt this morning, promoting my daughter's varsity soccer team going to regionals in Tampa next week. Go Eagles! If you have a question of your own, and it does not have to be within the realm of personal injury, wrongful death, product liability, anything like that that I do throughout the work week. A lot of people checking in this morning. Good morning, everybody. You can ask me anything you want, and I'll do the research that I think I have to do to give you a educated response to the question, but you just have to be tuning into the following week to get your answer. Or if you can't do that, then you can go into any one of the libraries where you can find these podcasts. Basically, the show is recorded and preserved so that you can hear it later on. So I was looking into my notes from 2 weeks ago because that was the last time I was live on the show. And I took notes that Jeff from Juno Beach called me about a probate question. So I did a little bit of research into Jeff's question. I'm going to be talking about that today. And I also had two questions come to me that listeners or viewers didn't see because they came into my cell phone, and I'm going to be dealing with those as well. A question regarding landlord-tenant issue and who's responsible to either clean or replace an old air conditioner. And then, boy, that cell phone issue's hot. Every once in a while, we get into an issue that hits a nerve. That guy that called in who had received by mistake a cell phone delivery to his home but wanted to keep the phone using the old finders, keepers, losers, weepers doctrine. He really irritated a lot of people. I'm getting a lot of feedback on that. So I got so many phone calls about that, honestly, that I just didn't return all of those phone calls. If anybody wants to call in and discuss the issue, I'm certainly open to it. But that was my topic 2 weeks ago before I went on vacation. I talked about civil theft in Florida, and that was specifically for that issue. So if you want to call into the radio station, if you're watching on Facebook Live, this show also airs live on 8:50 a.m., which is based out of West Palm Beach. You can call 877-850-8585, and you'll be live on the air with me. You can ask me anything you want.
From Don from Delray.
All right, we have a long-time listener. I'm assuming it's Don. Don, good morning. How are you?
Hi. Can you hear me?
I can hear you, Don. What's your question this morning?
Hello?
Well, Don, we can hear you. Yep, you're going to have to speak up.
Yeah. Okay, sorry. Yeah, I'm a long-time listener, and I'm sorry about your dad. I had a similar situation with my wife who died unexpectedly.
Oh, I'm sorry to hear
that. But the reason I'm calling is a few weeks ago you interviewed a gentleman who had a phone that he picked up.
I told
and
you.
It wasn't his.
Everybody's
from a carrier.
Everybody's irritated with this guy.
I have a little bit of a twist on that, and I was wondering what you thought. I had sold the phone on eBay and mistakenly shipped it without having been paid. It was shipped to a third party, not to the eBay party, and they still haven't paid for it. And I've applied with eBay for an unpaid item, and that'll be settled hopefully on Monday. I don't think he's going to pay. So my question is, do I still own the phone because it hasn't been paid for? by either third party or eBay member.
Well, that's a good question, and if Don, I got to cut you off because I've got a lot to cover today, and I know that you called me about this specific question. So let me just tell you what I think. I think that you do still own the phone until it's paid for. So if there's a way to recover the phone because you haven't been paid, then certainly you can try to do that. If this recipient of the phone lives in Florida, then you can utilize Florida's civil theft statute so that you can either get your phone back or 3 times the value of the phone plus your attorney's fees and cost in doing that. If this recipient doesn't live in Florida, then you'll have to check the state's laws for where he lives to see if there's a similar statute. But if you're going to be made whole by eBay this coming week, then that's probably going to be the end of it, because once you receive compensation for the phone, I doubt that you're going to be able to make a plausible argument that you should have the money and the phone. So,
right, no, that I understand. My question would be, can I block the phone, or put a hold on the phone's operating system through EMI setup?
Block the phone in what way? Don, you want to block the phone doing what?
Your connection's going out.
You're breaking up.
Oh, all right. I'm sorry, Don. We're gonna have to cut you loose, Sharina. I'll just touch base with Don after the fact. Don is, like I said, one of our longtime listeners. Contacts me quite frequently. Hey, what's up, Jay? Good morning. And I will deal with him offline because I do have quite a bit of things to cover today. I wanted to give a very specific shout out to Jesse. Jesse came by my house yesterday. He is a delivery driver for UPS. And he didn't have a package, but he knocked on the door. I actually knocked on the door twice because it took me a while to get to the door. But he stopped by just to say, just to give his condolences for the loss of my father. And I really, really appreciated that. He was just had wonderful things to say. And I doubt very highly that Jesse is watching or listening to this, but in the event that he is, I just wanted to say thank you. That was very much appreciated. So let's talk real quick about Jeff's question. Jeff from Juno Beach called me a couple weeks ago and had a question about how to deal with CPA fees that are owed by an estate because the debtor since passed away. So probate claims are regulated by statute. There's also a lot of case law, jurisprudence. But essentially, this is the immediate answer to the question, Jeff. And then, of course, if there's follow-up, you can always call me. If anybody wants to call me privately on my cell phone, that number is 833-VASTOLA. That's 833-VASTOLA, 833-827-8652. So you need to be focused, Jeff, on the deadline to file a creditor claim in the probate. And it really depends on essentially whether you are a known creditor or not. Because if you are a known creditor, the personal representative of the estate has an obligation to notify all known creditors, and then you have a very short window of opportunity to present your claim. If you are an unknown creditor, if the personal representative of the estate simply is not aware of your existence, then you have a much longer period of limitations to submit your claim to the estate. But you have to be very proactive to find out if an estate has been opened, where you would make your claim. So essentially the deadlines are this. It's 30 days after the date of service of the notice to creditors on the creditor. So if you are a known creditor and you receive notice from the personal representative, you have only 30 days to perfect your claim. It's 3 months after the first publication of the notice to creditors, or 2 years from the date of death for known or reasonably ascertainable creditors who did not receive notice to creditors. So, Jeff, for those CPA fees that have gone unpaid, you would simply have to fall into one of those 3 categories. And as always, if you have any follow-up, let me know. So, moving on to my next question, it was a phone call from a lovely woman who is having landlord-tenant issues, unfortunately. All landlord-tenant issues are covered in Chapter 83. At least statutorily. Of course, you can have a written contract. Most people do, either a residential or a commercial lease. And those contracts are regulated by case law, jurisprudence. And most importantly, they're regulated by the terms of the contract itself. Florida, like I'm sure every other state, gives freedom to parties to contract and negotiate, take on responsibilities, and pay whatever they want to pay, with very, very, very limited exception. So, for example, you cannot contract for something that's illegal, and you cannot contract with another person that doesn't have capacity. So, if you're going to sign a contract with somebody that you know is no longer has their mental faculties, and you have them sign a contract that says you're going to give me all of your assets, and I'm going to pay you $1, then obviously that's not going to work. But your residential or your commercial lease agreement is certainly going to carry most of the weight. But Florida Statute Chapter 83 is there in the event that there's any questions about the lease or something that's not covered. And it, like I said, it covers residential, it covers commercial, and it also covers storage facilities in Chapter 83. But this question pertained to a residential lease agreement, and the question was whether the landlord was responsible to either come out and clean what is apparently a very old AC unit or replace it, as opposed to that expense being borne by the tenant. And I don't have the lease, I wasn't given the lease, and so this is very general advice. The advice is first look to your lease, because oftentimes, and very often in commercial lease agreements, but oftentimes in residential lease agreements, the responsibility of whether to maintain an AC unit is on the tenant, is written into the lease. But here's the thing, it's often written that the tenant is obligated to maintain the unit, but the landlord is obligated to replace the unit. So as you can imagine, that creates this question of, okay, well, does the unit need to be cleaned or replaced? And if, the tenant is probably going to find somebody that says it needs to be replaced, and then the landlord is going to find somebody that says that no, it just needs to be cleaned, and there you go. You're off and running to the courthouse. Hopefully, reasonable minds can get together and say, okay, let's figure this out. But without having seen the actual lease agreement, it's impossible for me to weigh in and say, okay, who's responsible to pay for this? But this is what I see in the future, is this unfortunate dispute as to whether it's a system that needs to be replaced or just cleaned. Now, in my experience as a homeowner, I've been told that AC units, at least the ones that have been installed around my home, typically last, I think, between 7 to 10 years, and maybe that's expanded to 8 to 12 years. But they don't last forever, especially in our environment. And even if they're well maintained, they typically don't last beyond 12 to 15 years. If there's any AC experts out there, you can certainly weigh in and tell me if I'm wrong. But that's my understanding, is that as a homeowner, you're expected to replace your units, best case scenario, every 12 to maybe 15 years. And in this, it wasn't really a discussion that I had with this caller. She called and left me a voicemail message, but in this message that she left for me, this unit was coming up on 20 years. It was a very, very old unit. And so given that aspect of what I know about the situation, I would suspect that this is probably a unit that needs to be replaced pretty soon. But that's coming from, I'm just a lawyer. I'm not an AC guy. So hopefully that helps. Lastly, with regard to questions that were asked, I want to touch on the issue of punitive damages, because, and this is going to actually be posted on our website next week, the question of what are punitive damages, and when do they come into play, and how are they different from what you would normally get? Well, what you would normally get, and I typically put things in the context of a standard negligence case, and probably the most common is a car accident. You can have a slip and fall, you can even have product liability. There's all different kinds of ways that you can get punitive damages, all different types of cases. But typically, in a standard negligence claim, what you're asking for, the remedy, is compensatory damages, and the root word being to compensate. In a punitive damage context, you're asking for something over and above compensatory damages, and it very, very rarely applies, because punitive damages are meant to punish, the root of the word being to punish. So just so you understand, it's two completely different categories of remedy. The compensatory damages, at least in a standard negligence claim, would include all of your economic and non-economic damages. So there's a subcategory of compensatory damages. The economic damages typically that you would see are medical bills, past and future perhaps, lost wages, past and future, anything that you've paid out of pocket, whether it's prescriptions, if you had to get a special pillow, things like that. Accommodations made to the home. If now you're in a wheelchair and you have to make all different changes to your bathrooms and entryway and stuff like that, that's another economic damage that you may seek in the way of compensation. Now, alternatively, every once in a while a case comes up, and I think the most obvious example, as I was thinking about this and how it's best to describe it, is in an automobile context, if somebody is found guilty of DUI, that is probably the most common way that a standard negligence claim will also then seek a claim for punitive damages. If somebody is found guilty of driving under the influence and they injure somebody or, God forbid, kill somebody, you can expect that punitive damages are going to be sought as a result, because now the plaintiff, the injured party, is not just seeking compensation to be compensated for those things that I just mentioned. Oh, and the non-economics I didn't mention are your pain and suffering, loss of enjoyment of life, the intangibles that you can't really take out a calculator and look at receipts and tally it all up. A jury is left to decide, okay, what is the amount of pain and suffering that equates to this injury? All lawyers will tell you it's impossible to know exactly what a jury is going to do with the non-economic damages, but that is another category of compensatory damage. In a situation, the hypothetical DUI, now you've got, in addition to the compensatory damages, now you've got your punitive damages, because you're seeking to punish the wrongdoer. And punitive damages are regulated by Florida statutes 768. Specifically, there's several different statutes within that chapter. 768.72 explains how a claim for punitive damages is brought. And it's somewhat interesting. If you've got a case where you're expecting to bring a claim of punitive damages, you don't do it in the original complaint. Sometimes young, naive, inexperienced lawyers will file the initial lawsuit, and in that initial complaint, they'll make a claim for punitive damages. Well, you can expect that that pleading is going to get dismissed with an opportunity to amend, because the judge will say, you have to give me a showing first through evidence that you're going to have a basis for punitive damages. And so that's how it works. Procedurally in the state of Florida, you file your lawsuit for standard negligence, and then you build up your evidence by taking depositions, requesting documentation. In a case of a DUI, it would be, deposing the arresting officer, getting all the documentation supporting the arrest. If in fact there's a plea or a conviction, that type of thing. And then you file the motion to amend your complaint. You present all that evidence to the judge, say, look, judge, the defendant was drunk and hurt my client, and then the judge would most likely sign off on the amendment, granting now a complaint that seeks compensatory damages as well as punitive damages. So, what is considered a basis for punitive damages? It doesn't have to be just drunk driving. It doesn't have to be that. It says in the statute that I just quoted, a defendant may be held liable for punitive damages only if the trier of fact, based on clear and convincing evidence. That part of the sentence right there, based on clear and convincing evidence, that's what you have to present to the court. It's a very high threshold. I've had a claim for punitive damages denied because the judge said that we didn't have enough evidence to go forward with it. But it says, based on clear and convincing evidence, finds that the defendant was personally guilty of intentional misconduct or gross negligence. So it doesn't have to be intentional conduct. I don't know if some people would see a DUI as being intentional, or if some people would see that as being just gross negligence. I suppose it could fall into either category depending on how much was drunk and the person's thought process at the time. But it goes on to define these terms. Intentional misconduct means that the defendant had actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to the claimant would result, and despite that knowledge, intentionally pursued that course of conduct resulting in injury or damage. Gross negligence means that the defendant's conduct was so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of persons exposed to such conduct. So, that's what the court will apply, either one of those two standards, to say, okay, your motion to amend to bring a claim for punitive damages is either granted or denied. And then if your motion is granted or denied, you can oftentimes expect that that would result in some kind of an appellate issue. And the appellate issue is what we read about every week in my Florida Law Weekly. These are all appellate decisions where one side or the other is suggesting to an appellate court that the trial court made some kind of a mistake. But before I get into my Florida Law Weekly cases today, because I do have a couple of interesting ones, I wanted to talk about the limitations of punitive damages. Florida Statute 768.73 gives us our limitations, meaning what is the cap on a punitive damage. And there's a couple different ways that these come about. Now, I've had a couple of substantial jury verdicts in my career where punitive damages were applied, and the amount of the punitive damages were not stricken because they were literally calculated to be 3 times the amount of the compensatory damage. And that's essentially what the statute is saying. It says in subsection 1A, except as provided in paragraphs B and C, which I'll read in a moment, an award of punitive damages may not exceed the greater of, subsection 1 is 3 times the amount of compensatory damages. Or, number 2, the sum of $500,000. Subsection B, so this is subsection 1B, it's kind of lengthy, I don't want to read the whole thing. It says if the trier of fact, which at this point is the jury now, because the judge is the gatekeeper. The judge will say, yes, you can bring a claim for punitive damages, or no, you can't. But the judge, at least at the time of the actual trial, is not going to be the one to decide that number. Now, if the jury goes crazy and the number is through the roof and, frankly, in excess of what's in the statute, then the judge can issue what's called a remitter and reduce the amount. But for purposes of the jury's service and what they're there to do, it says where the fact finder determines that the wrongful conduct proven under this section was motivated solely by unreasonable financial gain, and determines that the unreasonably dangerous nature of the conduct, together with the high likelihood of injury, was actually known by the managing agent. This is when it's talking about somebody for a company or an individual. It says it may award an amount of punitive damages not to exceed the greater of 4 times the amount of compensatories, or $2 million, either one. Now, lastly, let me just mention this. This is important. Where the fact finder determines that at the time of injury, the defendant had a specific intent to harm the claimant, and determines that the defendant's conduct did, in fact, harm the claimant, there shall be no cap on punitive damages. So, very interesting, because oftentimes punitive damages, you see a lot of appellate decisions where the appellate courts are reducing the amount of punitives, especially in these tobacco trials and things like that. You see these punitive damage awards being reduced significantly. If you have a case where somebody did something intentionally with a specific intent to cause that, then there is no cap on punitive damages. So just keep that in mind. So hopefully that covers everything, at least all the questions that I had so far. If anybody has any questions, if you want to call into the radio station, we've got just probably a couple minutes. We have a couple minutes. We have 2 minutes, which is probably not enough time to call into the station. But if you want to talk to me, call me on my cell phone. My cell phone is open to you 24/7. The number is 833-VASTOLA. That's 833-827-8652. You can ask me anything you want. If you think that you have a case that I might be interested in taking, then we can certainly talk about that. I handle personal injury and wrongful death claims throughout the state of Florida. I have clients all over the state. You don't have to be right here next to me to hire me. But I'm here really as a resource. I really like to be available to people to answer questions. And if you do call me on my cell phone with what I consider to be a radio show question, please don't be insulted if I say, hey, please call the radio station on Saturday, because that's great fodder for people listening. You know, it's great fodder for topics. And I find that when people call in with their own issue, it generates a lot of interest, especially when you get a gentleman that called in saying, hey, I got a phone delivered and I want to keep it. I think that's funny. So anyway, thank you so much for tuning in. If you want to find out more about me, you go to my website at www.vastolalegal.com. I have an office in Palm Beach Gardens. I have an office in Stewart, and looking to very soon expand out into Okeechobee. So I don't think anybody out in Okeechobee is listening yet, but hopefully they will soon. Thank you to everybody watching on Facebook Live. There were an awful lot of people that were typing in the
1 minute.
Thank you, Sharina. And my news feed window, I know I've mentioned this before, but if you've ever hosted Facebook Live, you know what I'm talking about. The news feed window is about this small in the bottom corner. And I'm looking at it now. It only holds 2 individuals and their comment at a time before it gets pushed up. So the point is, if you've sent me something in the way of a question or a comment and I haven't responded to you on Facebook Live, my
30
apologies.
seconds.
Just because I didn't get a chance to see it and respond. But I do typically watch these when it's over, and I'll do my best to get back with you. But thank you all for watching. Thank you all for listening. Remember, if you need anything at all, call me at 833-VASTOLA. Hope everybody has a great weekend. God bless. Thank you, Sharina.